Sometimes the biggest things hinge on the smallest details. Today, we're diving into a case where a life sentence or a second chance came down to something you probably haven't thought about since middle school: grammar. Yep, the tense of a single verb.
So, let's start with this number, 325. Just let that sink in for a second. This isn't just some random number. It's a symbol of a legal system that, well, got pushed to a really wild extreme. That's how many years 3 men were each sentenced to prison. We're talking more than 3 centuries for first-time federal offenders. I mean, it's a sentence they could obviously never, ever live to serve. So the big question is, how on earth did they get a second chance? How do you go from a 325-year sentence to, well, not that? The answer is a totally fascinating legal puzzle. And the key, believe it or not, is hidden right there in the grammar of the law. Let's get into it.
All right, so to really get this, we first have to ask, how is a sentence like that even possible? It sounds insane, right? Well, it all comes down to this really controversial legal practice called sentence stacking.
Okay, so under the old federal law, the math here was just brutal. Let's say you're a first-time offender, and you used a gun during 3 separate crimes. The law didn't treat you like a first-timer. You get 5 years for the first count, sure, but then the sentences would stack. That meant a mandatory 25 years for the second count and another 25 for the third, and these are served one after the other. All of a sudden, someone with 0 prior convictions is looking at 55 years, and that's on top of whatever time they got for the actual robberies. It's wild.
And look, this wasn't just something that made people on the outside scratch their heads. The federal judges themselves, they were horrified. One judge called a similar stacked sentence the worst and most unconscionable he'd ever given out. Think about that. They were literally being forced by the law to hand down sentences they knew, in their gut, were just wrong.
So after years of this kind of criticism, from judges, from advocates on both the left and the right, which you don't see every day, Congress finally did something about it. In 2018, a huge bipartisan majority came together and passed the First Step Act. This was a really big deal, a landmark piece of criminal justice reform. And a really key part of this new law was getting rid of that sentence stacking for first-timers. The whole point was to stop these insane century-long sentences and, give judges back some of their discretion. But as it often goes with the law, when you fix one problem, you sometimes create a whole new puzzle. And this is where things get tricky. You see, the First Step Act wasn't fully retroactive. It didn't just automatically open the prison doors for everyone who got one of these stacked sentences. Congress had to draw a line somewhere to decide who was eligible. And the way they wrote that rule, well, it created a massive legal riddle. The law basically said that these new, fairer rules would apply to anyone whose crime was committed before the act was passed if a sentence has not been imposed by the deadline, December 21st, 2018. Now, I want you to really lock in on that phrase, has not been imposed. It's everything. Okay, so the timing of all this created what was basically a perfect storm for the 3 men at the center of our story. You can see their journey here. They were sentenced way before the First Step Act. But then after the act became law, something crazy happened. Their original sentences got vacated, like completely thrown out, because of a totally separate, unrelated legal issue. And this created a very, very strange legal vacuum. So this put them in this bizarre legal limbo. They're standing in a courtroom, needing a brand new sentence, but the First Step Act is already the law of the land. So the million-dollar question becomes, does the law see them as guys who had already been sentenced back in the day, or does it see them as guys who, right now, in this moment, have no sentence at all? Well, this question was so tricky, it went all the way to the Supreme Court. The majority, with Justice Jackson writing the opinion, actually sided with the men. Their argument? That these guys were essentially standing there with a totally blank slate. And the reasoning behind it? Honestly, it's a masterclass in using grammar to interpret the law. And it all came down to this: 2 little words, has been. The whole argument hinged on a really subtle but absolutely crucial point of grammar, the present perfect tense. See, the law didn't say the old rules apply if a sentence had been imposed. That would be simple past tense, something over and done with. No, it said has been imposed. And that tense specifically connects a past action to the present. It implies it's still relevant right now. Justice Jackson came up with a brilliant analogy to explain this. Imagine a rule says you're an Olympic champion if a gold medal has been awarded to you. See that? Has been awarded. It connects the past event, you winning the medal, to your status today.
It means you are, right now, a gold medalist.
Okay, but what if years later, that medal is stripped from you? Can you still go around calling yourself a champion? Are you still someone to whom a medal has been awarded in a way that actually matters today?
The majority's answer is a clear no. Once that medal is gone, the past event is legally voided. The connection to the present is completely broken. You are no longer someone who has been awarded a medal in any meaningful way. And this is exactly how they saw the petitioner's sentences.
The official legal term for this is vacatur. And when a sentence is vacated, it's not just put on pause or tweaked a little bit, it is legally wiped out, nullified. It's treated as if it never even happened. As the court put it, the slate was wiped clean. Poof, the men were left with no sentence at all.
But this was not a unanimous decision, not by a long shot. The dissenting justices, with Justice Alito leading the charge, had a totally different take. They basically argued that the majority was focusing on the wrong part of the sentence. So let's break down the two sides here. The dissent's argument really boiled down to this: historical fact versus current legal status. The majority, on one hand, focused on the word has as the key link to the present. If you don't have a valid sentence right now, then the new law should apply. Simple. But the dissent, they focused on the words been imposed as a historical fact, something that happened and can't be unhappened. They argued, look, a sentence was imposed back in 2012. The fact that it was later vacated doesn't change the history that on the day the First Step Act was passed, these men had a sentence.
So there you have it. Two really compelling but completely opposite ways to read the exact same phrase. So where did the Supreme Court land, and what does it all mean for the future?
Well, by a razor-thin 5-4 margin, the majority's view went out. The Supreme Court ruled that a vacated sentence is, for all intents and purposes, a legal nothing. It doesn't count. For the First Step Act, it is not a sentence that has been imposed because that critical link to the present moment has been totally severed.
And the real-world impact of this decision is just huge. For Hewitt, Duffy, and Ross, it means they'll go back for a new sentencing hearing where that stacking rule is completely off the table. Their sentences are going to drop from centuries down to decades. But bigger than that, this ruling gives a second chance to anyone else who gets caught in this weird legal gray area. It makes it clear that the whole point of the First Step Act is to make sure that no judge, from this day forward, has to hand down a sentence that even Congress has agreed is unjust.
And you know, all of this leaves us with a really big, powerful question to think about. This case, at the end of the day, wasn't just about grammar. It was about justice. And it was about something called retroactivity. When we, as a society, look back and decide a law was unfair, that it was unjust, what's our obligation to the people who were harmed by it in the past? Just how far back should we go to right those wrongs? How clean can we, or even should we, wipe that slate?